What's up, everyone? It's Peter Tragos, the lawyer you know, and today we finally get to interview Curtis Reeves' attorney, Rick Escobar, and Dino Michaels are joining me today for an interview to talk about everything Curtis Reeves. We talk his trial, we talk defense, we talk about what their favorite and least favorite witnesses are, what they thought the turning point of the trial was, how nervous they were throughout the trial, and what they thought about the prosecutors and the judge throughout this entire process. It's really interesting. We also talk about a lot of legal things and what it's like being a lawyer now versus back in the day, what it's like at Escobar's firm. So we get into a lot of different topics. It's a really interesting interview. Hopefully you guys enjoy it. If you like these kind of interview type videos, make sure you hit the like button and subscribe so we know that this is the content you're interested in. Let me know any questions you have in the comments. But for now, let's get to the interview. All right, we've got Rick Escobar and Dino Michaels here to talk about the Curtis Reeves trial, what everyone was calling the popcorn movie theater shooting case, which we'll get into how the media affects cases like this. But local criminal defense lawyers, been here forever, been doing their thing forever, and a really big victory we're going to talk about today. I really appreciate you guys coming on my show to talk about this case.
You're welcome.
Well, thank you for having us. I appreciate it.
Yeah. So this is not going to be a structured interview. We're kind of just going to talk about the case, about being a criminal defense lawyer, how it's changed over the years. I know you guys are kind of my dad's era, so I've grown up hearing the stories, hearing what it's like. I know Rick made some jokes about you guys being similar or close in age to Curtis Reeves when talking about how his age had to do with this self-defense case. And I think there may have been some bald brothers jokes made about you. I'm not going to make any jokes about being bald. I don't want to get slapped. And we have opposite hairstyles. So let's first off talk about how the media can really affect a case like this, especially when the narrative is so different than how you feel it's going to come out in trial. What do you do when you have such a strong media narrative that's negative for your client?
Well, this was frankly a case where right from the get-go, we had to hire a media professional really to help us out with the media. Hey, I shot this person over texting. I shot this person over popcorn was so powerful out there that we had no choice but to bring in some media professionals to help us set the record straight, because that was so far from the truth. In this particular case. In fact, some of the reporters actually came up to me and said, "Hey, look, Rick, this is being pushed by our editors. I know that, you are going to set the record straight. But this is just such a sexy line that they wanted to portray that from the get-go."
And the narrative is set by the media. So it doesn't matter what you tell them during an interview. For instance, the case took 8 years to get to trial. So there were all these stories and all these interviews, hey, Rick, tell us, why is the case taking so long? Well, we described to them in detail why it took so long, why it took so long to prepare, why it took so long to get to the courtroom, why it took so long to get to trial. And so no matter what you said, there was none of that in there. The narrative was always the same. Oh, they're just delaying things. They talked to the lawyer that was represented Mrs. Olson. And so his narrative, they're delaying it to keep the guy out of jail for so long, which couldn't be further from the truth in this case. Our client was the client who wanted to go to trial right away. He wanted his day in court. Your dad will tell you, and any guy who's been practicing criminal defense for a while, if somebody's out on bond, even if it's house arrest, a lot of times they take as long as you want. They don't want to go to trial. That wasn't the case here, but no matter what we said till we talked blue in the face, those interviews were cut and edited so that the end result was his lawyers are keeping him out because they want to keep him alive. It's ridiculous.
Yeah, and that's something that was asked kind of through our channel and the people that watch the show. And we talked about your case. That was something everybody wanted to talk about, is why is it taking so long? This takes forever. We've had cases that have lasted similar lengths. Most of them are civil, though. We haven't had a lot of criminal cases last 6, 7, 8 years. And we talked a lot about how the fact of having the stand your ground issue in the middle of your case is such a huge part of the delay. I mean, you basically tried the case twice. You dealt with changes in the law. You dealt with whether or not the new change was going to be retroactive or not. And we did a whole video on it just to describe what this delay is. And sometimes there's nothing you can do because you want your client to have the one fair shot, especially in a criminal defense case. We know how difficult it is to ever win an appeal, even based off something like the changing law. So, I mean, the fact that it took so long, I think, is pretty explainable, and we have gone through it in detail. But one thing I didn't really hear anything about in the media is how expert intensive the case was going to be, and that can take forever. And I know, especially one of the doctors you had, Dr. Foley, is in a ton of I do mostly personal injuries, in a ton of the personal injury cases. And I know he's had some delays around this time as well. So I know you guys played a video, but we were trying to depose him and stuff, and he had delays. So there's all sorts of delays that are out of your control, out of the lawyer's control, out of the client's control. And when you have a case that lasts this long and has such a strong, that helps the media narrative build, right? So when the trial first started and you guys were doing jury selection, what are some of the things you wanted to focus on when talking to the jury about trying to see if they had already made their mind up?
Well, as you know, that part of a trial is if it's not the most important, is certainly way up there. And so we really wanted to find out what these jurors were all about. It was very, very important for us to make sure that we weren't going to have a group of jurors that were biased against us, obviously. And so we had experts that were helping us. My investigator was around the clock trying to figure out who these jurors were and what biases they may have had. I think that played an important role because we had an excellent jury. We had truly, I think, a truly unbiased jury in this case. And I think that they were so attentive. I will tell you that throughout the trial, it was a long trial, and they were constantly taking notes. They were constantly focusing for both sides, not just for our side. And that was very, very critical. We needed to make sure that we were going to get a fair and impartial jury in this particular case. We knew that we were going to have an uphill battle with the judge. We knew that, none of these judges were going to stick their neck out for us. And so I think that, going into this particular case, we put a lot of focus on, those 6 jurors that were going to make the ultimate decision.
And one of the things that we did that was very interesting and very helpful is we took advantage of the ability to individually examine prospective jurors that had heard about the case in one form or another. So the question wasn't just, well, have you formed an opinion? If so, what is it? Can you overlook it if it's possible? It wasn't like that. We asked them how they heard, from whom. We got into all kinds of things. With each one of those jurors, we probably spent an hour with each one. And I think that was very helpful to really get to know someone, because anyone who's picked a jury knows that person sitting in that with that pool of prospective jurors isn't always going to be 100% honest. It's impossible practically to be in a room of strangers and tell somebody your deepest, darkest secrets. But if it's one-on-one, we were able to really get out a lot of things that, frankly, I don't think we would know about the person unless we were able to do that. And I think that was, in this case, very helpful. We also did some other interesting things. We did focus groups. Wonderful tool. A focus group that can answer some questions about what bothers them, what kind of things they'd want to hear. And so all of those things were very important in choosing a jury and picking a jury, because we could ask them some of those things.
Yeah, I mean, I always think it's the most important part. It's hard to pick the most important part of a trial, but to me, I feel like that's the most important part. And it makes, especially in the civil world, federal cases so much harder because you're not allowed to talk to the jury as much, and they kind of tie your hands about, what you can ask them. And we've seen in other cases, Dino, just like you mentioned, jurors are not honest during jury selection. Sometimes it can absolutely have an effect on the outcome of a case. Like Ghislaine Maxwell, I don't know if you've heard about that case, but the juror comes out and he actually was a victim and swayed the whole jury and lied on the jury questionnaire. That happens. And we've had cases here where we've litigated and appealed whether or not it's a lie or a mistake on the jury questionnaire. And I think it makes all the difference in the world. But watching you guys in trial, I do think you had a good rapport with the jury. And I think the jury did, like you and all that stuff. I don't really know what that means. I think they were listening to you, listening to what you had to say, and didn't hate you from the jump, which is all we can really ask for as personal injury or criminal defense lawyers, right? And from the jump and opening, Dino, when you stood very close to them, and played the video and basically told us what the video said and told it or showed and testified about the video. And there was some objections, and I know the judge eventually cut you off, but talk a little bit about how post jury selection, when you get that rapport with the jury, and I don't want to say pushing the limits because I don't think you pushed any limits, but doing what you can to represent your client within the rules, but really pushing to make sure the jury understands what you think is important, and even going as far as to get close to them and make sure they're listening.
And by the way, I don't think the judge cut me off from narrating the video. You know, it became an issue of style. So the prosecutors objecting, frankly, to my style. So if I say, well, the evidence will show, and you know, and as ridiculous as it was, I said, okay, judge, I'll say the evidence will show,
Right.
and I did it and went right on with what I wanted to do. We thought it was very important to show that jury that video because it's a shocking video. It shows a homicide, an excusable homicide, a justifiable homicide, but a homicide. So we wanted that jury to look at it as many times as we possibly could show it to them. That's why we showed them freeze frames, slow motion, this angle, that angle. We showed it to them from every possible perspective so that we are up there telling them this video helps us. This video shows why Mr. Reeves was in fear of his life or great bodily injury. And so that was you know, a move, a calculated decision to show them as many times. And I think that was important. And, you know, the other thing is, and you see it when you try a case with somebody else, you say, okay, Rick's the more aggressive guy. So he can't get up there with the jury because, you know, who knows? They may not care for him as much. Later on, they will. And if their kids get in trouble, they're going to run to find him. They may hate him, but, you know, they love to watch him. But because my style is a little different, you know, I started with the jury. And I think it's important to have that kind of flow. You pick a jury, and then you go to opening. So you've developed that rapport, like you said, Peter. You know, the state, for some reason, they chopped it up. They put a robot up there, you know, Mr. Martin, to pick a jury. He was asking questions. I mean, I don't know what he was doing, frankly. And then they put, you know, Scott up there, the other prosecutor, to do the opening. And then he starts his opening by making a mistake, by saying something that's not true. Now imagine this. It couldn't be more of a dream scenario for us. We have this jury that we want. We have this prosecutor, neither one of which is very personable. And then the prosecutor gets up there and misrepresents what the DNA evidence is. And so that was like a dream come true to start out the case. You can imagine.
Are you talking about how he said no marks or no injuries on him, or what are you talking about?
He was taught there was a stipulation as to the DNA that was found on the phone. Essentially,
on the phone.
There's a mix of 3 DNAs, and they really couldn't exclude or include anybody. What he said in opening was, no, the mix of DNAs excludes Curtis Reeves, so therefore the phone never touched him. He said something that was totally incorrect and to a jury misleading. So we get to start out the trial saying, look what they're doing already. They're trying to mislead you. And so, you know, those things happen. You know, those are what you wish for in trial. You're sitting there and then something like this happens and you take advantage of the opening. But, you know, we showed that video at all those different angles, all those different times for a reason.
So when every trial, what makes it so fun is we as trial lawyers have to be reactive. We've always got to be ready for the unexpected, and we've got to just ebb and flow kind of with what happens in the trial. And when we get an opportunity like that, you got to pounce on it. One of the things I noticed he said in opening that was shocking to me is that nothing happened to him, no injuries, no marks on his face, except for the mark on his face. Is kind of what he said in opening, which is always something that jumps on. And one of the parts of trials that non-lawyers like to listen to and look at are objections. And Rick, when you had some objections, which is a similar style to my dad, it's almost as if you were telling the judge how to rule on the objection. And the state would object and you'd say, no, judge, that's absolutely a proper question because in front of the jury and everything. And a lot of the times the judge would agree with you, or if she didn't, to a non-lawyer, and a lot of people on our show that were kind of commenting in about it were saying, I think the judge made the wrong decision because you were more convincing than even the judge's answer. So where do you get that kind of style? Does it come with experience? Is it always kind of how you were? And give me some idea about what some of the turning points of the trial were to you.
You know, I think it really starts with preparation. You know, you've got to be confident with your case. You've got to know the case like the back of your hand. And you've got to know what's coming, what objections are going to be coming, what problems we're going to be having with the introduction of evidence, what problems they're going to be having with the introduction of evidence. And so, that's our style as a law firm. All my lawyers are super prepared. And then, certainly with that particular ammunition that we have going into the case, sooner or later, this judge starts to realize that we know more about the law than the prosecution, and that we know more about the law than the judge. And that's really the way it should be. We all should be educating the court on what the law is, because we're the ones that are doing all the research. We're the ones that are preparing this case for trial. And so that's what I try to do. If I'm going to be up there being an advocate for my client, I better be an advocate that is convincing, because if not, not only is a judge going to lose faith in me, but the jurors are as well. That's my audience. Everybody, in fact, the entire courtroom is my audience. I think that, when I was doing some of the cross-examination in this case, some of the bailiffs would tell me that all of the other bailiffs that were helping and assisting were always coming into the courtroom when I was doing cross-examination, because they were so intrigued by it, about what was coming next. And so I think for Dino and I have been, working together for many, many years. And, what we try to teach the younger lawyers in my office is that you can't be too prepared for any case. And if you're very well prepared for these cases, sooner or later, the judges are going to embrace your knowledge, and they're not going to challenge your knowledge. And that's what we tried to do in this case.
So what were some of the turning points that you guys were worried about? Were there certain pieces of evidence or certain testimony that you were more worried about than others? And kind of how did you handle that when it came out of trial?
Go ahead, Dino. I just finished, so take the lead.
I mean, frankly, we were prepared for everything. There was nothing that came out that was a surprise. As a matter of fact, and I think Rick will tell you the same thing, we would go home every night, and we worked through the night too. The weekends we work too, and that's what other lawyers have to understand. They want to be successful at trial. You can't stop working on the case. And young lawyers have to understand that as well. The point is that we would go home and we say, they must have something up their sleeve. So there's got to be more than this. There's some surprise. So after a while, into the second week, I said, Rick, either they're Oscar-winning actors or the most prolific sandbaggers I've ever seen. But I don't think anything's coming. But we never stopped trying to figure it out. We would sit there, we would look at all different angles. The research that we've done on certain issues, we would re-research it and say, did we miss something? I think that's important. When Rick talks about preparation, that's what he's talking about. Even though you've done the preparation, if you have a question, you need to go back and you need to look at everything again. And that's what we did. So from my perspective, there wasn't. I think that we went home every evening and thought, this could have been a bad day for us. For instance, when Nicole testified, when Mrs. Olson testified, we were thinking, well, we might have a bad day here. Mm-hmm. They put her on first, and then they end by doing a redirect and showing her a still image of her deceased husband reaching across the seat towards Mr. Reeves, which was an attack that preceded the attack where the popcorn is taken from Mr. Reeves's person. And they show it to her and they say, don't you see your husband there reaching over? And she says, no. And so when they did that, whatever they did with her to make her sympathetic towards the jury, and how can she not be? That's why, how can I attack her? What am I going to say? But when they do that, and that's how they end it, they kind of ended it with a dud. They put out their own firecracker in a bucket of sand. And so from my perspective, there were no turning points. I didn't see it. Maybe Rick has some input on that.
No, I agree. When Dino and I went into this case and preparing for this case, right before the trial dates, we thought we were going to have a good day. We were going to have a bad day. We were going to have a good day. We were going to have a bad day. We were so surprised after the first week that we didn't have any bad days. I mean, we were really rocking and rolling, that first week, and thought to ourselves, there's got to be something else that's coming. And it never came. And so, I think that had a lot to do with our preparation. It really did. I've always been a firm believer that you can't over prepare a case. And you win these cases by outworking your opponent. And I think that's what we did in this case. And even though we were so prepared, Dino and I were always figuring, okay, what's coming? What could be coming? What would I do as a prosecutor? Because I was a prosecutor before I became a defense attorney. What would I do as a prosecutor in order to make my case a little bit better in this segment of the trial? And fortunately, none of that came. And I can tell you that, up until, the very end, we felt very, very, very good. I mean, obviously when we're waiting for a jury to come back, we're always somewhat
Sweating.
But I can tell you something funny. One of the prosecutors came up to me before I was going to do my cross-examination of the lead detective. And he said, "Hey, Rick, I just want to let you know that this witness has had diarrhea for the last 2 days because he was concerned of your cross-examination." And so that was the lead detective on the case.
You mean the lead detective where the prosecutor also said it was a horrible investigation?
Yeah, exactly. And so, those are moments that, I think, fortify, what we thought all along we needed to do in this case.
The other
Tell me about, you mentioned focus groups, and you also mentioned, Rick, having a personality that maybe takes time to love or something for the jury. What did the focus group say about Rick? Because a lot of people that watch my videos, a lot of them liked him. A lot of them didn't. A lot of them said he seems like a bully. I can't believe how he's beating up these witnesses and these poor cops or these poor people that were just sitting at the movie theater, and he's really digging in and, getting on them hard. What did the focus group say about kind of the style that he had cross-examining some of these witnesses?
Peter, we didn't ask him that question, but maybe the next time we do one for a case, I think we're going to ask him that. I think that's a good suggestion. Now you bring that up, I think that's a wonderful suggestion. We'll do that.
It may be something he already knows. I think maybe I have an inkling that he already knows it. So another part of the trial that a lot of people had comments, this is kind of what I want to bring, because all the people that listen to the show, they have a lot of questions and want to ask you guys kind of what you thought about this. But a lot of people were saying, oh, his closing was way too long. Doesn't he know his closing was too long? It was this long, whatever. It should only be 30 minutes, it should only be an hour, whatever it may be. And kind of my comment as somebody who doesn't have the case was, usually criminal defense lawyers don't have this much good evidence. And this case, while albeit sometimes boring, had a lot of expert testimony that I thought was brilliantly connected to get the point across, to see, yes, we need all this to explain that it couldn't have been about the popcorn because there wasn't enough time. We need all this to explain that, yes, the cell phone hit him in the face. We need all this to explain that there were multiple, attacks on him or aggressive points towards Mr. Reeves. So all that expert testimony, and including, how, I hope this isn't offensive, this is what the whole defense was, how old he was and decrepit he was, and, how that makes a big difference. So what was your thought process, Rick, when you did this closing? Did you feel like it was long while you were doing it? Were you worried about it? Because you also had a lot of law to explain, which was also on your side of the case.
Yeah, I agree. And in most of my closing arguments, you want to try to keep them a bit shorter because you certainly don't want to lose the attention of the jurors. I think what happened here, obviously we had a lot of material that we had to cover. But if you noticed, almost from the very, very beginning, when I was doing my closing arguments, I really felt that jury was embracing me. I don't know if you realize how close I got to them. I was at their podium there. I was at their within a foot of them for probably, I'd say, 75% of my closing argument. And I felt that was very important because I wanted them to embrace me. I wanted to embrace them. And the feedback that I was getting throughout that entire closing argument was that, hey, they understood what I was asking them to do, and they were embracing that. I had, frankly, a couple of the jurors actually wink at me throughout that closing argument, which gave me, a lot of reassurance that, they were going our way. I think that, when we were preparing for that closing argument, as I was preparing and Dino and I were shooting back ideas, of how we were going to structure that. I think it was very, very important to educate them well on the law, because the problem with the justifiable use of deadly force law in Florida is that there's a great misconception about that law, and people, and I don't mean this in a derogatory sense, but they're quite ignorant on how to apply that law. And so I spent, as you can remember, a great deal of time talking about these jury instructions and actually how they were supposed to apply that law to the facts and circumstances of the case. I think that, even though it was a very long closing argument, I never once got the impression, as I was looking at them, as I was talking to them, that they wanted me to sit down. And so had I gotten that impression, I would have shortened it up quite a bit. And in fact, I will tell you this, once we had done the closing arguments and we had finished this case, we always think back, was I too long? Did I get enough information out there? This was a trial that when I sat back after the closing argument, I really felt good about it. I really felt that the jury had grasped everything that I had tried to give them. And, I will tell you, as hard as it is waiting for this jury to come back, I felt confident, and Dino felt confident. We really felt, like this was going to be a victory for us. And, knock on wood, thank God that, that happened.
Yeah, and I mean, we can feel good about cases or feel like a jury's with us and lose. It happens. I mean, you're not going to win every case you feel good about. So it's not like you're sitting here saying that. But when you can reflect on some cases, you feel like I did everything I could, and at that point, it's up to the jury and we all sweat it out no matter how good our case is, usually. At least that's my perspective. What is your feeling, Dino? And you've kind of already hinted at it. What was your feeling at the way the prosecutors handled the case and what their strategy was and how they decided to attack it? What was kind of your feeling being in the courtroom?
One of the things that I noticed was that they didn't seem to be on the same page. Rick and I, we knew what the other person was doing. We knew why they were doing it. We had discussed it ahead of time. What do you think about this? Dino, what do you think about that? So we knew what we were going to do. We were on the same team. That group sitting there didn't seem to know that. For instance, I did a direct of Mrs. Reeves. Now we had a transcript from a deposition. We had a transcript from the immunity hearing. And so I know what all the negative things that I can ask her. Now, they knew over the weekend that we were going to be calling Mrs. Reeves on Monday. I do my direct, talking to her about all the negative stuff that could come up on cross. The judge, okay, cross state, what minute, judge? Now, imagine that. The jury is watching this. They put their heads together. I thought I was going to hear a clunk like the Three Stooges almost. They put their heads together and you can hear them whispering. What are they going to do? What are we going to do? And the jury's looking at them. And that happened several times. Rick will tell you that happened with several witnesses where the judge would say, okay, redirect state, 1 minute. And they would huddle up, audibly whispering with the jury looking at them like, what are they going to do? And so when you see things like that, it makes you think that, they're not on the same page. When you hear a mistake in opening regarding some stipulation by the parties, it makes you wonder how truly prepared they were. There were small things too, and you see it, I know, in the civil world where there's a lot of tech and all that stuff. A lot of lawyers that are in criminal, they still get a big easel with a piece of paper. And the prosecution did some of that. Even though they had this whiteboard, they got an easel with a piece of paper on it to show them. And when they go to exhibit their evidence, they were fumbling around. One guy's holding the keyboard there, looking, I'm trying to do this, I'm trying to do that. A jury sees that. It's a small thing, it would seem like to a layperson, but a jury is wondering, this is the government, it's the state of Florida. If they're looking, fumbling and bumbling around, how can you trust that they're doing the right thing of prosecuting this old man? And so, those are the kind of things that I noticed during the trial that, frankly, if I were a juror, I would be wondering what's going on here. We had, for instance, we're big on these notebooks, okay? Big trial. I'm sure your dad used some big
Oh
notebooks.
yeah.
And these big trials have a gazillion notebooks. We had a whole office filled with notebooks. During the trial, we have these rolling carts. We bring in notebooks. Every day we bring in bags and bags and bags. We have these notebooks. So what they're facing where the jury is, and they're on this cart. Mr. Rosenwasser makes an objection. Judge, I want them to turn the jury's looking at those notebooks, because on the binder they would have the witness's name, and a white binder if it's our witness, a black binder if it's their witness, and have the witness's name. He asked the court to instruct us to turn the cart. And so I'm thinking to myself, I stopped myself from doing it, but right away I'm thinking, Judge, what is the objection? The defense seems too prepared, or I don't understand the objection. So we turned the cart for him, but it made even more of a ridiculous scene for them to say something like that. And so
yeah. One of the things that's interesting about this channel and having people watching be able to comment is I ask them questions like that. What do you expect out of a lawyer? If you were on a juror, if you're a potential juror, do you expect tech? Do you expect piece of paper? Do you like it? Do you not like it? Overwhelming majority expects lawyers to know how to use some kind of tech, no matter how old they are. And they expect it to be professional and practiced and smooth and look good and not fumbling and bumbling around. If you're going to make as much money and charge as much money to do this, highfalutin job, and you're a professional, then they expect something out of it, and that's kind of how we always think about it too. So Rick, I want to get kind of your thoughts on the prosecutors, but I want to mention, like I did in our conversation initially, I thought the best thing Scott did was get Curtis Reeves off the stand, to have him stand next to him so you could see how humongous he was next to Scott, who's not a big guy in his own right. But, you're trying to say this guy is, the person that was really scared. But when he got off the stand and stood next to Scott, I was like, whoa, he looks like a monster there, which I thought was very interesting. And only Scott potentially could have pulled off. But Rick, what did you think? How did you feel like they did?
Well, listen, Glenn Martin, I think his caseload at the state attorney's office was 3 cases. Wow. He had an incredible amount of time to prepare this case. Scott came in the last year. And so, Scott was a little bit behind the 8 ball as far as, information that he had on the case. But, Glenn Martin had an enormous amount of time to prepare this case. His problem was he was myopic. I mean, he didn't see the big picture. He was always focused on, that, whether it was a phone that was being thrown or whether it was the shoe. And he lived and died, by that focus, in my opinion, because he didn't realize that whether what we were seeing in the form of a light, whether that was a shoe or whether that was the phone, the fact of the matter is that Mr. Reeves had gotten hit with a phone because Chad Olson's phone was in between Mr. Reeves's legs. And the only way that it could have gotten there is if it had been thrown. And so, in my opinion, certainly, they mismanaged the way that they should have tried this case. First of all, they were wanting to convict Mr. Reeves on a second-degree murder. They would have had a much better theory of prosecution had they focused on a manslaughter, to say, hey, look, he made a mistake. He overreacted, but again, I think that, Glenn Martin was so focused on getting a conviction on a second-degree murder that he lost sight of what was, a reasonable theory of prosecution in this case. I was a former, prosecutor, and I handled many, first-degree homicides. And, sometimes, you can overcharge some people, and the jurors don't like that. They want to make sure that prosecutors are being reasonable, yes, aggressive, but reasonable in what they're seeking to do. And here, I think that they really mismanaged that theory of prosecution.
So we've talked about all the experts. We've talked about all the work in the binders you guys did. I think you had 4 lawyers there, all the tech. What's a defense like this cost? That's something people want to know. I mean, how much does this actually cost to put all of this together? Because it's not pro bono and it's not cheap.
Well, let me talk on that a little bit, because, as you know, while we were defending this case, we had many clients that we also had to represent at the same time. I want you to understand that Dino and I have a full caseload of clients that we're representing, and that we're putting in as much time, as much effort, as much expense in their defense as well. And, you don't have to spend enormous amounts of money in order to get this type of defense. Unfortunately, in this particular case, because of all of the issues that propped up in this case, and because of the volume of witnesses that we had, and because, frankly, a lot of the things that were coming out in the form of information was untrue, we did spend a lot of money, with experts. But in most criminal cases, you don't have to spend anywhere close to $1 million in order to get a competent defense. What you do have to do, and we have a luxury in Florida, as you well know. In Florida, we have one of the most liberal discovery states in the entire United States. We get to take depositions in preparation for trial. In fact, I will tell you that in the vast majority of our cases, we're able to destroy the government's case way before trial comes around. Why? Because we've taken these depositions, and even before the depositions, we've done enormous investigations that by the time we get to depositions, we're destroying the government's witnesses right there before their eyes. That's what we do here, at our firm. And as a result, we don't have to go to trial in the vast majority of the cases because, we're really able to either, get these cases dropped, or we're able to get prosecutors to become reasonable, and we get very, very good resolutions. That's how we operate here at this firm. And so I don't want people to think that, hey, just because, you have a case of this magnitude, that you have to spend close to $1 million in order to defend it. Because I can tell you that in the vast majority of the cases that we defend day in and day out, we spend a very, very small fraction of that, and we get great results. I just had recently an individual that was extradited from Mexico on a contract killing. It was a cartel case. They extradited him from Mexico. They hired us. And within, I think it was probably 120, maybe 180 days of him being brought back, we were able to destroy the government's case and show that the fingerprints that they thought belonged to my client were not my client's fingerprints. And so they had to drop a first-degree murder case and get egg on their face. And I think we probably spent in that case maybe $5,000 in cost in being able to do that. So, these cases just take work, they take dedication, they take passion. When we start talking a little bit about the olden days of practicing criminal defense versus today, I'll talk a little bit about that because I think it's very important.
Yeah, before we get to that, I do want to get to that. But the last thing kind of on the Curtis Reeves case for Dino, talk a little bit about what it's like to prepare a client to testify in a criminal defense case. How would you feel like Curtis did? Because that was, in my opinion, everybody's always like, is this defendant going to testify? Is Kyle Rittenhouse going to testify? Is Curtis Reeves going to testify? And my opinion is, in most cases that are self-defense, the defendant has to testify, has to talk about what his belief was. What was he thinking? What was he feeling? How did he react? So, we always knew, especially in this case from the Stand Your Ground hearing that he testified, that he was going to testify. So what was that like, and how do you think he did?
Well, I know how he did. He did fantastic. and I can tell you, if you want to look at the difference between his testimony at trial and his testimony at the immunity hearing, you're going to see the work that Rick, in particular, put in preparing Mr. Reeves to testify. You talked about the time when Scott has him get off the stand. Well, Scott did a lot of things to get under his skin, right? Here's Scott, who's kind of a diminutive-sized guy. Here's Curtis Reeves, who they're looking at, well, he's a police captain, and so people have to do what he says. And Scott's ordering him around. Remember the point in the trial where Scott's making him read the transcript out loud, making him read a statement, making him get down. And like you said, Scott's getting in his face. So if anything's gonna tip, some ornery old ex-police captain off, that's gonna do it. But it didn't happen, and that's where real lawyering happens. Yeah, in the courtroom, and that's the fun part, and that's the cool looking part, and that's the part that people see. Real lawyering happens preparing those witnesses. The same as we prepared all our witnesses. I can't tell you how many. Well, thank goodness for Zoom. Last time we had to meet with them in person at the place we were staying, but we prepared each and every one of them, and not just one time. Time and time again. that's key. And in terms of Reeves, Rick that was good. To me, that was great lawyer in this case.
Yeah, it's like practicing for the game.
It was the best. And then, and then again, it's one of those things where, you get the old adage, you teach young lawyers, don't ask a question you don't know the answer to. So Rosenwasser gets up there and asks him that question about, is he sorry or something? I can't remember the exact question. And Reeves put it beautifully. If you don't feel something, then you're not human. He gave him the perfect out, and that's how he ended his cross exam. So think about that again. That's another time when you're going to ask a question that's potentially dangerous. There's no need to take a chance there. And if he didn't ask that, Rick was going to get up there and redirect, and that question was going to come out because he was prepared for that, because we knew that's what they were going to ask. So there were no surprises to Mr. Reeves on questions. Believe me when I tell you that.
Yeah, and there's certain things from law school that stick unnecessarily, like saying the evidence will show, as opposed to just explaining what the evidence is going to show. But then there are others that stick that are appropriate and should, which is don't ask a question you don't know the answer to, and finish on a strong point, especially in cross. Like, you got to finish on a highlight, get in and get out sometimes. If you can find something that's good for you in every witness, right? Some more than others. So final thoughts on the Curtis Reeves trial. What do you think was the one big thing, if you had to pick, that was the most important thing in the trial that swung it in your direction for the jury? I know it's probably impossible to pick one thing, but just pick your favorite.
Well, I think that if you talk to Gloria Gomez with Channel 13, I think she'll tell you what that one thing may have been. And that's my cross-examination of the lead detective, where I asked him, or actually I told him, that the reason that his investigation was so flawed was because he didn't have any experience in the investigation of self-defense cases, and he admitted it. I think that was a major blow to this case. I think not only did this detective did not want to admit that, but when he finally admitted it, you should have seen the jurors' faces. I thought their jaws were going to hit the floor, because here's the lead detective. He's arrested Mr. Reeves on a second-degree murder case on a clear self-defense issue, and he admits to this jury that he was incompetent to investigate a self-defense case. I don't know of anything that could be more damaging to a prosecution's case. In fact, to be honest with you, we had taken his depo. I think we had about a day and a half of depositions with him, an entire day and a half of depositions. And we came pretty close to him saying what he said in that trial in depositions. But frankly, when that came out, it even shocked me that he came out and was so candid about his incompetency. And so as you remember, I left him alone at that point in time and quickly sat back down.
What do you think, Dino?
Well, definitely picking the right jury, because it's difficult for some of my colleagues. I have these defense lawyers coming up to me. You think they would know what justifiable use of deadly force is and what a crazy sounding law it is. I mean, frankly, it is. But one after another, it's impossible, really derogatory things, including all the experts. But during the trial, I think that, and so to get a jury to understand that, I think was the penultimate victory to get the right jury, which we did. Because, by the way, they did an exit interview with one of the jurors that was it was one of the alternates. And so they asked him after, what do you think? Oh, guilty, 100% guilty. So, the six that we got were the right ones. During the trial, I think when our use of force expert got up there, and the last thing out of his mouth, my last question was, so in your opinion, your expert opinion, did Mr. Reeves fire his firearm in retaliation or in reaction to the throwing of popcorn? And he said, no, absolutely not. That was a dagger. That was a killer right there, because their whole argument, even at closing, even after that, at closing, they're arguing, you can't shoot somebody over popcorn. I mean, I think that those were the words they used. You just can't do it. You can't shoot somebody over popcorn. Here you had a guy that was super well respected, that, by the way, they didn't touch with a 10-foot pole on cross-exam. If they did any, I think they did very little. And just happened to be, which was a wonderful, imagine, we Weave's the guy that they used in the Draker case. So imagine how that comes out when we're there. Yeah, this guy right there I testified for. I mean, imagine how powerful that was. And then his opinion is, first of all, the jury gets the picture. Well, the state of Florida hired him at their trial. They didn't hire him on this one because he's saying it can't be over popcorn. So, I mean, that was just, to me, in the trial, not just because he was my witness. I'm not saying that. I think I love what Rick did to that detective. That was the guy at the end had this bizarre nervous tick. I thought he was going to have some kind of a seizure. But anyway, I think that expert opinion coming out in that very succinct, very simple way, not a whole bunch of nonsense about use of force continuum, which by the way, we were thinking of that and then ultimately decided, let's keep it simple, go right to the point, which we did. And I think that was, for me, another big point in the trial.
Yeah.
One of the things that I want to mention, and Dino handled this witness, and I think it was another very important part of the trial, is our pathologist, who actually educated the jury on how vulnerable the human body is. One of the real problems that we had with this case is that, as young kids, we've all been in a fist fight. We've always gotten into skirmishes as a kid, and we've taken a punch and we've thrown a punch. And you remember, people saying, hey, don't bring a gun to a fist fight and don't bring a knife to a fist fight. So we really had to educate this jury on how vulnerable the human body is, because I think that a lot of the jurors didn't understand that a simple punch in the right place to the human body could either cause death or great bodily harm. And, Dr. Adams, who was the medical examiner here for Hillsborough County for, I think, 10 to 12 years, with Dino's guidance, gave an incredible explanation from head to toe of all of the areas of the human body that were so vulnerable. And I think that really helped the jury understand what Mr. Reeves understood. Because remember, as a homicide detective, as a decorated law enforcement officer, you're at the medical examiner's office all the time, and the medical examiner is educating, those that are there on really how vulnerable the human body is. I think that really played a very important part in this case. And Dino did a wonderful job of being able to take that jury from the top of your head to your toes in explaining that.
Yeah, I agree with all of that. I think, to me, as kind of like an outsider listening in, especially things I didn't know about before watching the entire trial, that made a huge difference to me was cell phone, potentially being thrown and hit him in the head, the gunshot residue, potentially he was making a fist, in combination with, and this is something that, if I was a prosecutor, I'm sure they did object to it. And you can tell me kind of if there was discussion on it, but the fact that Reeves never shot anybody as an officer.
How did we get that in? How did we get that in?
I don't know how that's relevant.
We were shocked. We thought we would never get that in. And when it came out, it was like we had hit a grand slam.
that changed, that flipped the switch in my mind. We're like, this guy is not a cowboy. This guy's not looking to shoot people. This guy is reserved. This guy is not looking to kill anybody, even when he, could easily do it probably multiple times in the line of duty. Yet with the cell phone, with the fist, with the guy coming over, with his old age I was pretty positive in my head at that point he was in fear for his life, right? And that's kind of where you got to get. But yeah, I agree. I was like, but again, that comes off as preparation, looking at every little detail and what parts are going to be important and how you can fight to keep certain things out that you have to take the time and preparation to do and fight about. Like, sometimes people get lazy and don't want to fight about little issues and they come out. I loved your guys' argument during JOA where you're like, they put on his testimony. So we were shocked they put on his testimony, but they did. And so we think we win right now. That's the truth. It's like, why? That was unnecessary in my opinion, but they did. So that was just from an outsider's point of view, some big ticket items that I think swayed from, especially where the case started. Where the case started, you can't shoot somebody over popcorn. You can't shoot somebody over popcorn.
You could see we were not getting any help from the judge on any of our arguments. Okay?
Exactly. But you still fought him.
She did not want us to win. Put it that way.
Right. So when talking a little bit about what it's like now versus what it used to be like, what are some of the big differences? Do you think it's going in the right direction, the wrong direction, and what can we do to fix it?
No, I think it's going in the wrong direction, and I will tell you, I started as a lawyer in 1983, and I can tell you that our criminal justice system was far different. I think your dad will tell you the same. Judges back then that were on the bench had, for the most part, had very successful careers, not only as prosecutors, but as defense attorneys and civil lawyers. And now we're on the bench and they were giving back to the community in their near retirement days. And so we had, judges that experienced life, that they knew about life, and they could relate to, that little boy that grew up with no father, with 10 siblings in the ghetto. And these judges back then really loved trials. They loved reading about cases. They loved the litigation. They loved the battle. You don't have that as much today. You have much younger judges. You have, judges that frankly have only been prosecutors. And then when the JQC calls you, for opinions on them, and you're telling them, hey, listen, how much did these lawyers make before they applied to be a judge? And they're telling you, oh, well, they made, $60,000 a year. And you're thinking to yourself, why? They want to be a judge for a salary, or do they want to be a judge to really give back to the community and to administer justice as it needs to be administered? In this particular case, I will tell you that in one of our arguments, we gave the judge an opinion. It was a 25-page opinion, and the judge's response in this Reeves case was, "You mean I have to read a 25-page opinion?" And so, unfortunately, we're getting that sort of resistance. And as you know, in today's day and age, judges are more concerned about how they stack up in their caseload. In other words, the Supreme Court wishes for judges to streamline their cases and to have an efficient flow of cases through the system. And the most important thing to judges today, and I hate to say this, but it's the truth, is who has the lowest caseload, because somehow judges thinks that means that they're great judges, and that's far from the truth. How many cases you have and how quickly you dispose of cases has nothing to do with whether you're a great judge or not a great judge. And so it's disappointing, I will tell you, very disappointing in today's day and age, how justice is administered. It wasn't that way back when I started. It wasn't that way when your dad started. But unfortunately, it's really deteriorated, and it's now about just how many people can we move through the system, how quickly. That's what it's about. And if it doesn't change, I just don't know what's going to happen to our system of justice. I really don't.
What do you think, Dino?
Well, I think I'm seeing more lawyers and less lawyering. That's what I think. And so I'm concerned about the profession from the other side of the bench. Yeah, there's a lot of great young lawyers, but I'm not seeing, the quality. I don't think in terms of dedication. I can tell you that from being around some young lawyers. I'm not disparaging young lawyers. We need young lawyers. We need good ones. But when I'm in a courtroom, and criminal law has always been the wild, wild west anyway. Why did I get in this game? Because I can be creative. I can shoot from the hip sometimes.
Yeah.
I can find different things. I can make these arguments. I don't have to be an intellect, but I can be street smart and be quick on my feet and do pretty good as long as I do my studies and prepare. But I'm not seeing that like I used to. I used to go into courtrooms and hear some pretty cool stuff, and it could be part of it. Could be a product of what Rick's talking about. That we have a cattle call mentality now, where we're just moving them through. We have judges say, well, I'm not going to give you any more time for that. I don't care if you have to do depositions. It's just a third-degree felony. We hear things like that, and when I hear something like that, it makes my blood chill. I think Rick actually tells the judge, hey, if this was your son that I was representing, would you want me to have more time to take depositions? So when I see stuff like that, and I strictly practice on the criminal side, it's a little disheartening for me. That's That's my 2 cents.
Some of the times we obviously interview lawyers all the time for, positions when they become open here at the firm. And I can't tell you how many interviews we've been in. Dino and I and the rest of the lawyers were interviewing these young lawyers. And one of the first questions that comes out is what are my hours? And I'm thinking to myself, what do you mean? What are your hours? Your hours are whatever it takes to represent that client competently. That's what your hours are. And I think that, in today's day and age, remember when your dad and I first started, it was the practice of law. I mean, that's how we defined ourselves, the practice of law. In today's day and age, in my opinion, in the minds of many young lawyers, and I hate to say this, but many young lawyers, it's just a job. And that's wrong. You can't have, I can tell you that in my firm here, this is the practice of law. And whether you're an old lawyer like Dino and I or a young lawyer, that's the mentality that we're going to have here, because that's the only way to practice successful criminal defense, in my opinion. Frankly, it's the only way to practice any area of the law successfully. And unless that changes, you're going to see, the continuing degrading of our system of justice.
And I can't tell you how many interviews we've had where in addition to what are my hours, we always like to ask the question, why are you a lawyer? Why do you want to work here at this firm? Well, we expect to hear what I would say. If you ask me that, I would say it now. I want to be a great lawyer. I want somebody to say, oh, that Dino, he's a pretty damn good lawyer. That's what I want people to say about him. These guys say, I want to be a judge. We get these lawyers in here that are not even 30 years old, and their goal in the legal profession is to become a judge. I was astounded. To me, I'm like, if I can bat 300, I don't want to call balls and strikes. Here's a guy coming in. He doesn't even know if he can bat 300. He wants to get behind the plate and call balls and strikes. It's amazing. And it's not just one or two we've had. I can't tell you how many that have said that.
Yeah, I think that with the millennial stereotype, we'll say law is not a great profession to fit into what that stereotype is, where you got to be flexible. You got to care a lot about feelings. You got to care. And it's not, people will try to make the mental health argument. To me, I feel better when I'm more prepared. I'm less anxious on the case when I'm more prepared. I have no fear, no anxiety when I'm prepared and I go into this expert depot or I go into this trial. When I'm sweating is if I'm ever not prepared. That's the only time you really got to be nervous and stuff. And it really is a profession that, especially a trial lawyer, right? I do think you can kind of have a job mentality if you're certain kinds of government lawyers, not a prosecutor, but I mean certain kinds of government lawyers, or if you do just sit there and write contracts or in-house counsel. I think there is a job element to that more than the practice of law. It would be better if it was the practice of law, but I think different areas can kind of have some differing things. But especially for trial lawyers, you got to have a certain personality that you love it. You're all about it. You find that joy in the success, in the fight, in the argument, in the ingenuity, in the creative ability, and in the wins and the losses. You feel it. It can't just be a job that you don't care about, which I do think is part of the problem with some prosecutors. Like, it doesn't matter whether they win or lose, so they prosecute cases they shouldn't prosecute. Same thing with civil defense lawyers sometimes. Like, they get paid no matter what, so they're just milking it to the end, go to trial, and it doesn't matter. And one of my issues with a lot of judges, like Rick said, is they're being prosecutors, only prosecutors. And the biggest problem with that is they've never had a client. They don't realize how it affects the clients to delay this case. Oh, I hate when I'm in a motion to continue 2 weeks before trial on a civil case. They asked me this question: has this case been continued yet? Judge, why does that matter if this case has been? That's not one of the elements that every case has to get a continuance. But it's like they think, we'll continue. It's just one continuance. Wait 4 more months before your day in court. And it's just not. You wouldn't want it for yourself or your kid, like you said, and you definitely don't want it if you've had a client.
Yeah, and part of the reason that happens, I'm going to tell you, Peter, the reason that happens is because a lot of lawyers are not prepared. A lot of lawyers don't do the work they have to do. And so when a judge sees them come in, judges know which lawyers do what. That's why I don't think Rick or I or your dad or you are going to have a problem getting a continuance, because the judges who know know that you're prepared. But what happens, a lot of these judges are going to push everybody through the same way. And it's funny what you should say about anxiety and being prepared. And when you're prepared, you don't feel pressure. You don't feel anxiety. You're comfortable. My wife, because we took the 3 weeks during a trial and we rented a townhouse at Lake Jovita. So we were holed up there, didn't see our wives for 3 weeks. My wife sent a blood pressure cuff with me because she wants to make sure that I'm all right. And Rick knows, we're in the car together. I'm reporting, honey, it's 104 over 71. You know, she's, what? How's it so good? Because sometimes she'll see, I'll have some crazy, crazy client or something like that. And I'm I have to talk them into trying to do something to save their own life. And she sees my blood pressure, you're going to court, tell me what's going on. So this whole time we were so well prepared that my blood pressure was so low. Rick saying, maybe you should stay up here.
It's a nice golf course up in Lake Jovita.
Yeah. It is, but what you say is true. And I think a lot of, that's a good solution to a lot of problems for a lot of people in this practice, is to be prepared, and then you're not going to feel that pressure or be
just don't take my blood pressure when my client's getting crossed. Just not then, because I'm probably sweating under my suit. It's what we can control. That's the best part, is when you can control it, you feel a lot better about it. That's just how it is when you have this type of personality. I don't know what it is. It's just, it doesn't even have to be type A. It doesn't have to be super aggressive, but it does have to be like, you have pride. You have pride in your work. You have pride in what you do. If not, just do something else. Your law degree can be really, really helpful in a lot of different things. Okay, I've taken up so much of your guys' time. I appreciate it so much. This was so fun, just learning from you guys and getting some insights from lawyers that have been doing it for a long time, some of the differences of criminal and civil law and what it was like back then. Congratulations on a big win, and hopefully maybe we'll talk again in the future if we have something else come up.
Sounds good.
Take care.
Thanks, guys.
Bye-bye.
Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.